In this lesson, we will begin our extensive discussion on the concepts surrounding raising of capital. Now, at the very outset, we looked at the concepts surrounding the different forms in which people can go into business, namely from sole proprietorships to partnerships and finally companies. As I noted at that stage, the bulk of this course, evidently as the title itself suggests, deals with companies, both in its private and its public forms. In the discussion of raising capital, this being the fundamental requirement for the establishment as well as the running of a company, we need to look at it in the context of both private companies as well as public companies. Now, when it comes to public companies, we refer to this as equity in relation to raising of capital. The requirements and the regulations for this are quite much more onerous in itself than that of private companies, a fact that we will also consider a bit later on in this lesson as well as in the course at large, primarily due to the fact that when it comes to public companies, it deals both with the public interests as well as funds accumulated from the public at large. Having said that, we need to firstly, before we go into this topic, understand the premise and introduce the notion of public companies and the requirements to be considered as such. So on the one hand, when it is a public company, it must be publicly stated as such. In other words, you must set yourself out as a public company at the very inception. There are instances, however, where you have companies which started off as private limited companies that move on after an initial public offering to becoming public companies. Similarly, you must set yourself out by appending to your existing name the prefix PLC or public limited company. Also, much like what we looked at in a previous lesson as well, there is a minimum share capital requirement, unlike in a private limited company, where a public limited company must have a minimum share capital of £50,000, as outlined in Section 763 of the Companies Act of 2006. Finally, there must be provisions made to provide prospectus for investors to get a better understanding of the value of the company before investing or before putting their money into it. As you'd notice, even at this stage, the regulations are far much more strict, and this particular topic as well, in terms of raising of capital, we will be looking at the actual methods by which capital is raised, but more so towards the regulation in order to prevent the abuse of this system. Contrary to popular belief, and this is something that fundamentally everyone believes it to be so, a public limited company need not always be listed within a popular stock exchange. It need not be in a stock exchange whatsoever. It can exist outside of it. While this is not the norm, there are examples, there are exceptions to this rule, where you see, for example, Sir Alan Sugar's famously incorporated Amstrad PLC is in fact something that exists outside of the stock exchange. The reason for this is the London Stock Exchange in this context, or any other stock exchange for that matter, is in fact a private entity, and it too has to have its own private contractual arrangement between itself, which is the stock exchange, and the company, the public limited company. So it is in fact a choice. It provides better opportunities for the company to raise funds because it's in itself a listing body that provides that information to a greater audience, but it need not be as such. Now that we've had a basic gateway or into this particular topic, so to speak, we'll have a look at the methods by which companies or public limited companies essentially raise capital before we proceed on to the regulation of such. So on the one hand, one of the primary and fundamental ways by which public limited companies raise capital is by offering its shares for subscription. Another way in which commonly public limited companies do provide an opportunity for themselves to raise capital is to offer said shares for sale. In this context, a public limited company will engage an issuing house or a merchant bank and provide said bank or the issuing house with the entirety of their shares to be sold to specific clients within that particular issuing house or the bank or the public at large. Many public limited companies essentially might opt for this because the advantage of this is that the risk of selling such shares is in fact borne entirely by the issuing house, and it indemnifies the company for the most part. Similarly, when there is an initial public offering or when a private limited company will turn into a public limited one, there is an opportunity of raising capital by offering new shares to existing ordinary shareholders in a proportion which is sufficiently fair for said ordinary shareholders. This provides an opportunity to raise more capital as well as to convert shareholders as well in one go. Similarly, you have placing or placement, where unlike the other methods that we just looked at, where you either offer it to an entirety of the public, a certain large mass of people who are clients or the existing shareholders, capital is essentially raised by a very handful of investors which are handpicked as opposed to the public. This too can be handled by a merchant bank. That was a quick outline of raising capital, or an introduction as such to raising of capital by public limited companies. Now, at this juncture, it should be clear that the requirements of raising capital for public limited companies is highly regulated and it's much more onerous. These were just a few instances or few mechanisms by which raising of capital occurs. But the majority of this topic will in fact deal with the regulator and the regulations in place to prevent fraud, to prevent abuse, to prevent insider trading and so on. So from the next lesson onwards, we will focus and have a look at the regulations which are in place to prevent such fraud or abuse of power.